live.
Good afternoon. Today is March 10th, and this is the House Judiciary Committee's bill hearings. The chair is currently away, but should be back shortly. But we're going to go ahead and get started. The bill order today is going to be House Bill 1293 from Delegate Henson, House Bill 1168 and 1178 from McComas, House Bill 1142 from Delegate Attar, House Bill 1344 from Delegate Bhandari, House Bill 1268 from Delegate Long, and House Bill 1320 from Delegate Arakan. And we're going to start with House Bill 1293. Again, witnesses, mute yourselves until it's your turn to speak, and members raise hands when wanting to ask a question. The proceedings are being live streamed from the General Assembly's website. All right, House Bill 1293 from Delegate Henson has 7 people signed up favorable. Eliza McDermott, Nicole Hanson-Mandel, Christopher Dews, Amir OFJ, Kesia Monroe, Crystal Williams, and Stacy Bensky. So we have Delegate Henson. You have 3 minutes when you're ready.
Chair, thank you, colleagues, members of the Judiciary Committee. For the record, I am Delegate Shanika Henson, and I'm here today to present House Bill 1293. The bill makes an exception to the child support system's driver's license suspension program for child support obligors making less than 300% of the federal poverty level. If this subject matter sounds familiar, it's because your very own colleague, Delegate Deborah Davis, filed a similar bill last session, which was House Bill 580. It has trusted me to file the bill this session and hopefully be able to make an impact in this area of Maryland's law. We understand that across the state of Maryland, mobility is key. The Census Bureau reported in 2019 that almost 50% of Marylanders travel outside of their county for employment. That statistic is even more pronounced when we look at lower income communities where personal use of a vehicle is not as prevalent. For example, only 9% of jobs in the Baltimore region can be reached within 1 hour on a one-way commute by public transit. That means that the ability to be able to drive your car is economic empowerment in the state of Maryland. In 2015, NPR reported that 62% of Marylanders who owe child support make less than minimum wage. We then compare that to the practice that's in place with our child support enforcement agencies. When a person fails to make their child support payments as obligated, if a person fails to make those payments for 2 months, the Child Support Enforcement Office has the ability to suspend their driver's license. They can suspend their driver's license without guaranteeing that a person has received notice of it. So we have Marylanders who are driving around right now with a suspended license who possibly don't know that that's the status of their license. When a person is pulled over for driving on a suspended license, there is a possibility of incarceration and being levied with fines as well. I'm asking the committee to pass this bill because we understand that being able to have mobility is key to being able to support yourself, to support your family and your children. I ask for your favorable support, and I ask you also to consider the testimony of the witnesses who are here today, who also have worked very hard to make an impact in this area. Thank you.
All right. Next, we're going to hear from Eliza McDermott for 2 minutes.
Thank you, Chairman and members of the committee. My name is Eliza McDermott, and I am a University of Baltimore law student and a Rule 19 student attorney in the Civil Advocacy Clinic, where I help represent low-income individuals under the licensed supervision of Professor Dan Hatcher. We're proud to support HB 1293 because it will support work, not block work. This bill is needed to reduce harm to low-income children and families. The current license suspension policy makes it even harder for non-custodial parents to work and pay child support, prevents non-custodial parents from driving their children to school, doctor's appointments, or other needed trips, and exasperates systemic poverty and racial inequality the disparate negative impacts on Maryland's Black families. For example, license suspensions in Maryland have a disproportionate racialized harm. Black Americans constitute roughly 31% of Maryland's population, but between the years of 2015 and 2020, they represented 71% of license suspensions. Also, importantly, HB 1293 is consistent with federal law. Federal law simply requires that each state has and uses, in appropriate cases, authority to withhold or suspend driver's licenses of individuals with overdue child support payments. This bill should be construed as consistent with that federal requirement. I therefore submit this test in support of a law that supports work, not blocks work, and respectfully request a favorable report.
All right, next we'll hear from Christopher Dews for 2 minutes.
Thank you, members of the committee. My name is Christopher Dews, and I'm the Senior Policy Advocate of the Job Opportunities Task Force, where our mission, as always, is to help lower wage workers advance to higher wage jobs. We support House Bill 1293. We want to thank this House sponsor, Delegate Shanika Henson, for taking on this legislation, and also Delegate Deborah Davis for handling it last year. This is a very, very important bill when it comes to access to transportation. As the delegate already mentioned, half of Maryland workers travel to another county for their place of employment. Only 9% of the jobs in Baltimore can be reached within 1 hour one way by public transit. That means 90% of the jobs cannot be reached within 1 hour. Interestingly enough, when special session hit, my car was down and I had to take public transit to try to get down here to Annapolis. And after waiting an hour and a half, the bus actually never arrived. And I had to apologize to my former trainees, because when I ran a training program and they would talk about the transit system, I don't think I took their issues seriously enough. And when you stop and think about access to employment, if you can't get there, even if we got you the job, which is what we did in workforce development, we get you the job. But if you can't actually get there or get there on time because of public transit or because of lack of transit access, then we have a massive problem on our hands. And how can an individual pay their child support if they don't have access to employment, which leads to the necessary funding needed to pay off these specific issues? So for those reasons, we actually urge a favorable report. As is already mentioned, this is a racialized impact as well. We need to get more and more people to work. And the best way we can see to do that is to eliminate this license suspension mechanism for lower income obligors making less than 300% the federal poverty line, which is roughly about $39,000 a year. We thank you, urge a favorable report. Thank you.
All right. Next, we will hear from Amir OFJ for 2 minutes.
Yes, good afternoon. My name is Amir Lewis. I'm the Voters Registration Fellow as well as the Rapid Response Fellow for OFJ. I'm in support of HB 1223 because I'm directly impacted by the child support system. Directly impacted because the two kids that I have that I'm down child support for, they live with me. So it's difficult for me to do my job in the community, as well as take my kids to events, school events, and to spend time with them because child support has taken my license. Thanks for having me on.
All right, thank you very much. Next, we'll hear from Crystal Williams for 2 minutes.
Good afternoon, Vice Chair Moon and members of the committee. Crystal Williams with the Office of the Public Defender. I'm here today in support of HB 1293 because this is an important step and necessary component to other similar bills and efforts to stop criminalizing and penalizing poverty. Too often and for far too long, undue financial hardships have unfairly impacted Black and Brown communities, keeping many in generational cycles of poverty. Those living below the federal poverty line should not be further strapped with fines, fees, and restrictions on their livelihood beyond their means, particularly when such restrictions and penalties can lead to unnecessary contacts with law enforcement, resulting in arrests and additional onerous fines and fees. Maryland must do more to address the historically embedded and vast pathways that continue to cripple and directly or indirectly criminalize indigent individuals and families. And for those reasons, we are in full support of this bill and ask for a favorable report. Thank you.
All right, next we'll hear from Stacy Bensky for 2 minutes.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Stacy Bensky, and I'm a family law attorney at Maryland Legal Aid. You might read Family Law Article 10-119 and think, why another exception? Why, if we already have enumerated exceptions in the law to stop license suspension, if it would impede employment, or if the obligor is disabled, or if the obligor is paying on their arrearage balance per payment agreement. Well, unfortunately, the Maryland Child Support Agency uses an automated driver's license suspension system that operates as if those exceptions that you might see now in the statute do not exist. Their automated system does not remove obligors who fit into one of those enumerated exceptions from the pool of people who can be selected for license suspension each month. The only thing that stops an obligor from being in that pool of people is if they get their arrearage balance down to less than 2 months of arrears. So until that happens, they can be repeatedly selected for suspension. So I have many clients who need their driver's license for employment, and they pay extra each month towards their arrears by an earnings withholding order. So they would clearly fall under the exceptions in the statute. However, month after month, they're continuously selected for license suspension. I have their license reinstated, and then a few months later, I get a call from the same client, my license is suspended again. This could be easily remedied by suspending driver's licenses only when appropriate on a case-by-case discretionary basis. And that's what the controlling federal law says. It says that state agencies have the authority to suspend, quote, in appropriate cases. Driver's license suspensions are not appropriate or effective for someone living in poverty. It's an obvious barrier to employment, and it harms the entire family. It's harder for a non-custodial parent to be an involved parent if they don't have a driver's license, and it punishes entire families for being poor. We urge the committee for a favorable report, and we hope that the law is correctly implemented by the Child Support Agency, because if it is, we believe it will help break the cycle of poverty for so many low-income Marylanders. And I'm happy to answer any questions that you have. Thank you.
Thank you. We have one question from Delegate Tolles.
Thank you, Mr. Vice Chair. I have a question for the bill sponsor, Delegate Henson. So thank you for bringing this bill forward. I just had a couple questions. In speaking to the current law, if the purpose of suspending a license is to encourage a parent to pay their child support, can you speak to, why are talking about the current law, can you speak to why we suspend licenses in Maryland without considering how the suspension will impact the child support?
Thank you, Delegate Tolles. That is an excellent question. I believe the testimony from Ms. Bensky touched on it as well, that we are suspending licenses without taking that consideration that you mentioned in your question. If the ultimate goal of the family law article when it relates to children is the best interest of the child, if the ultimate goal of the agency is to collect payments to be able to support the child, having the type of analysis that's envisioned in this bill would make our process much more effective and much more fair to all parties involved. When we look at the mechanisms that are available to the department, suspending driver's licenses to enforce compliance is actually the least effective method. It looks like intercepting tax returns during financial matches with financial institutions to garnish from bank accounts directly. You're intercepting unemployment benefits and intercepting state lottery benefits are all have a higher success rate in getting payments than the driver's license suspension program. So I do think the question poses a interesting question for the department and how we best support and implement our goals.
Okay, and then thank you, Delegate Henson. And my next question is, do you know of any other situation in which someone's driver's license is suspended for other obligations that they don't pay?
That's a great question. Other than perhaps obligations to the Department of Motor Vehicles and renewal requirements that come along with having a driver's license. I'm not aware that we suspend driver's license for other obligations that people owe. This does seem to be a very unique program.
Okay, so only for rearages that you know of, for child support rearages that the state suspend driver's license.
That's correct, Delegate.
Wow, that's incredible. Thank you so much, Delegate Henson.
Thank you.
All right. It looks like that is all of the questions on this bill. And wait, Delegate McComas, go ahead.
Yes, thank you, Mr. Chair. I appreciate it. This is for Delegate Henson. Just I know that several times we've had experts come and when we were revising the child support guidelines and everything. And I'm just wondering is that also part of the problem, that in other words, if a person's making 39,000 and even if the spouse is making more or less, that basically they have to be able to provide for their basic needs. I mean, they might not be living at the Ritz-Carlton, but they've got to pay rent, they've got to pay electricity, they've got to, pay car payment, have to eat food. And I'm just kind of wondering if, and now, I mean, with inflation, I'm just wondering if we need to reevaluate those guidelines as well to look at it. Because as I understand, 39,000 is in other words, if they're below 300% of the poverty level. So in other words, so we're saying 39,000 is hard for these folks to live on. Is that correct?
That's correct, Delegate.
Okay, and that's for just one person, right?
That's correct.
Okay, so I mean, it would be helpful if you could, it's not necessary, but if you could provide kind of like a table, so for one person, for a family of 4, just so we kind of get a feel for what's going on. But I just, anyway, what do you think about that? Is it the guidelines as well as the the 2 months behind that's really triggering the problems, or is it that the guidelines for the 39,000 and below is really causing problems too?
Thank you for the question, Delegate. As it relates to the federal poverty line and what the threshold is that we're asking the committee to use, I also have an amendment which I would put up for the committee's consideration, just to clarify that provision. The individual obligor, their income is the threshold for triggering this exception under the federal poverty lines. So even if the obligor is from a household of 4 or 5, we would be asking for the bill to read that it would be the obligor's individual income that would be assessed to determine if they qualify for the exemption. As it relates to the kind of inner working of orders being established and orders being enforced, the data does show that when orders are established at limits that are beyond a person's ability to pay, that the compliance rate with those orders is certainly less. So there are movements across the country to right-size child support orders to make sure that the amount that's asked of an obligor is in alignment with their ability to pay, so that we can encourage more compliance and we don't find ourselves in situations like this.
Thank you. Did Ms. Binsky have a comment? Stacy?
Oh, yes, if that's okay that I jump in. What I was going to say, I think they're related, but I really think this is a separate issue. I think that the fact that you're automatically going to potentially have your license suspended over and over and over again is, until you get down, you get your arrears balance below 60 days or 2 months worth of arrears, is like the crux of the problem. Because like I said, I have clients who they are working, they are paying actually, because the child support agency automatically, when you owe a certain amount of arrears, adds on 25% to go towards your arrears balance. So we have people who they are paying, and they're paying extra, but their license is still being suspended. So if you're working a job, and I know a lot of my clients are at jobs where they have to have a driver's license, they're driving trucks, things like that. You're working a job like that, if you don't get fired, which you might get fired. The other thing is, you're that day, like I've had clients call me and say, my boss just told me to go home for the day. You're working an hourly job, you don't have PTO, you don't pay time off, right? So you're not getting paid for that time. So I think that the license suspension, like the guidelines may or may not be an issue. I think another issue along with that is that child support orders are often backdated to the date that that the person first filed. And those cases take a long time to be established. So people start off with arrears if it's backdated to the date of filing. So you're starting off like right off the bat in the position that your license is likely going to be suspended because you're starting off with over 2 months worth of arrears. I mean, a child support case takes far longer than that to go through the establishment process, at least in Baltimore City, which is primarily where I practice, and I believe in other counties as well.
Thank you.
Delegate Cox.
Thank you, Mr. Vice Chair. I'm not sure, Delegate, it's good to see you. I'm not sure which member of your panel may be able to answer this, but I'm just curious now. Number one, the proposed amendment to make this an individual obligor only income-based seems to then open this to, and by the way, I want to preface everything I'm saying by saying I like the bill generally. I mean, I think there needs to be some relief in this area, and I appreciate you bringing the bill. I'm just a little concerned if your individual obligor income is the standard, and I'm looking at the the average income in Maryland, it's exactly 300%. The poverty rate is exactly the average income of most people in most counties in Maryland, including Baltimore City, except for a few outlying counties that have much higher rates. So my concern there is this looks like it may be exempting everyone potentially that may be paying child support. I'm just wondering, is there a mechanism then to make sure that we're not preventing child support from actually happening? Because, you know, obviously we don't want the income to end, and we don't want the job to be terminated because of the lack of a driver's license. That's horrific. I think that needs to end. But at the same time, if they're not paying, the dad or mom on the other side is going to lose their job and lose their car. And, you know, so, you know what I mean? So I'm just wondering if there's a mechanism that you've thought through on that to make sure we don't lower this so much, because I saw the judiciary's comment in the fiscal note says that it's actually not that federal law requires driver's license suspensions to enforce child support, except that there's no apparent prohibition on income caps, which that's why I think your bill is so attractive. But if the income is so broad that it is encompassing of so many people, I'm just concerned. I guess that's my primary question. I don't know if I made it clear.
Your question, Delegate. To kind of take in the scope of it, when we asked for data from the department on license suspensions, enforcements that happened in fiscal year 2020, because they suspended the practice during the pandemic, of the 109,000 automated enforcement actions that they had, the license suspension was activated in 6,900 of those cases. So it's a part of the program that they have, and it's not the most effective part of the program that they have to collect payments in these cases. Again, the payments that are collected by tax intercepts, payments collected by intercepting unemployment benefits, payments that are collected by garnishments from bank accounts and other financial institutions, those ones have much higher collection rate than the child support agency suspending licenses. And one of those problems is, one, the breakdown in communication. Obligors don't always have noticed that their license is suspended before it is. So with the automated process, you can't reach the person and impact them with that kind of coercive or deterrent factor if they don't have any knowledge of it. They simply find that out when they're pulled over or they apply for a job and the employer comes back and says, we can't hire you for this reason. And instances where people do have notice of it and have the ability to seek from the department an exception, you can see that that can be very difficult when the system is triggered automatically and there is no mechanism in there for review. As you heard in the testimony, this could result in someone having their license suspended over and over and over again. So I do think that the scope of it is manageable and that it wouldn't result in our state falling into a status where we weren't supporting children and families. The other methods are there, and I do think that it would provide more due process in the enforcement in general when we had a system for review.
Excellent, excellent. Thank you. That's very helpful.
Yeah.
And like I said, I like the bill.
Could I jump in and say that, yeah, earnings withholding orders are really the most effective way to get consistent payments. So typically, the license suspensions are really only more effective for higher income bracket obligors who have the ability to pay and are just withholding. Or that it might be, or it's seen also to be effective for like a one-time payment, but not a consistent payment. So the earnings withholding orders are the way that, at least from the data we've seen, that is consistent payments, which is the goal, right? And in terms of just, I wanted to address, because Delegate Cox, you had asked about the federal law. If you actually look at the controlling federal law, which is 42 USC, it's 666A16, it speaks to the authority that the states basically have to have the authority to withhold, but not licenses, but not just driver's licenses. It also, in the same exact sentence, it says they have to have the authority to withhold driver's licenses, professional, occupational licenses, and recreational and sporting licenses to be used, as I'd stated before, only in appropriate cases. So there's no automatic system for professional, occupational, or recreational or sporting licenses. Those are used, it's discretionary. And so the agency still would very much have the ability to suspend driver's licenses. And in some cases, it might be appropriate, right? Just like in some cases, it might be appropriate to suspend a professional license or a sporting or recreational license. But the law, the federal controlling law, in no way says there has to be any automatic system. It's just that they have to have the authority to use it. And again, that same law also says when it's effective for increasing, or when it's used to increase the effectiveness of the program, which is to support children and families and financial stability. And from what we've seen for low-income families, it just doesn't do that.
Thank you. Excellent. I appreciate the answers.
Sure.
All right, another bite from Delegate Tolles.
Thank you, Mr. Vice Chair, for letting me have another bite here. Just to add on to what Ms. Bensky was speaking of, having that authority. And so Delegate Henson, do you feel like this really helps the children when the parent's license is suspended, even though there's authority to do so? Can you speak to that?
Thank you for the question. When the ultimate goal is best interest of the child, and that's being reflected through collecting payments, there are methods that are much more effective. Ms. Bensky spoke about the wage withholding, where payments are taken directly from an obligor's job that they receive W-2 wages at, the other enforcement mechanisms that the department has available to them. But suspending the driver's license has a unique collateral consequence, and that's that it withdraws the parent's ability to be able to drive around, to be able to support themselves with work, and also to be able to be a present partner in their children's lives when they don't have the ability to drive them to and from soccer games, schools, things of that nature. So it not only ties their hands financially, but it really does have the ability to remove them as a resource for the family in many other ways.
Thank you.
If I could just add on very quickly to that, just with a piece of data, the ABLE Foundation did find that in 2017, only half of non-custodial parents in the state child support program were employed, and only 50% of those in Baltimore, Maryland were employed, but 43% of them made the minimum wage or less. So I just want to just hammer down that, you know, this is, for us at least at JOTF, this is a massive employment issue. We've had to turn people away because we at least in my workforce development experience, we've had jobs, cannot stress this enough, but because the individual did not have a license, because it was suspended for their child support arrears, then we couldn't put them in a position where they would be able to comply with their orders. And as Stacy mentioned, just want to hammer this last point one more time, and that is that an individual may be able to make an initial payment, but once you consistently suspend licenses, they end up in this vicious cycle of being in compliance and then being out of compliance and then not being able to maintain employment. A lot of the people that we work with are side jobs in Uber and DoorDash and things of that nature. When you don't have a license, you can't participate in a lot of Maryland's newest gig economy. So I just want to stress that suspending licenses specifically for this target economic population does not benefit themselves, the parents, the custodial parent, or the child or themselves or their ability to be able to, be a part of the family. So I just want to just make sure that we know this is a massive issue when it comes to employment. Thank you.
All right.
If I could say something real quick, please.
Briefly, please. Briefly.
Just to piggyback off of what the other delegate said, my family wasn't broken up. It's the way the system is designed. It's designed if the parent is if the female is pregnant, the system is designed where as though if you're getting any type of assistance, TCA or TDAP, or with my case, daycare vouchers, the system makes them take the dad down to child support, to file for child support in order for them to get the benefits for the daycare voucher. So to make it clear, and again, to piggyback off of what the other delegate said, my family wasn't broken up. It's the way the system is designed in order for her to get the assistance that she needed for us to take care of the kids. She had to take me downtown. Thanks for the time.
Mr. Chair, we're on the last question on the first bill from Delegate Martin Howell.
All right, Delegate Martin Howell, go ahead.
First of all, thank you, Delegate Henson, for bringing this bill to us. I have a question for Mr. Christopher Dews. I've known people who have gotten their license suspended. They end up in jail because they get so far back on child support. Do you think that this bill will help us to keep people out of jail and with their license?
Yes, short answer is absolutely yes. As I may have mentioned before, 43% of those who are currently on the child support system earn the minimum wage, but owe an average of $10,000 in unpaid arrearages. When an individual can't pay, they do risk incarceration as well. And if it's called contempt of support, I believe. So that's another mechanism that we have to look at. But as I said, suspending a person's license just leaves them crippled when it comes to trying to obtain employment, specifically in the state of Maryland, since half of Maryland workers have to travel to another county for employment, specifically in lower income communities. So I do believe that moving this piece of legislation, freeing up this barrier to employment, is going to reduce incarcerations as well.
Thank you so much.
Thank you.
All right. Are there further questions for this panel? Seeing none, I think that concludes the testimony of those in favor. I think I see everybody in favor of House Bill 1293, and we thank you very much. So we're going to move on now to House Bill 1168, Delegate McComas. We'll hear from Delegate McComas, Judge Kathleen Dumais, Dorothy Lenig, Lori Ruth, Michelle Smith. We'll hear from everybody. I think it's being heard in JPR. I wonder if they're available. Delegate McComas, do you know if your witnesses are available? Are they in the room? They are in the room. Okay, that's fine. We see Dylan. Dylan says yes, so that's fine. We'll hear from you and for Judge Dumais for 2 minutes each, and a minute for everybody else. So Delegate McComas, go ahead for 2 minutes.
Oh, thank you, Mr. Chair. HB 1168 and the cross-filed SB 849 have been presented by Delegate Dumais, now our circuit court judge in Montgomery County, for many, many years, it seems like. Both of us were on the custody decision-making, I think it was a commission by the governor, and we worked with a lot of different experts, and then they split up in different groups. Anyway, a lot of work was put into it. And so lots of practitioners, fellow legislators, we had some judges, we had some masters, they're now called magistrates. Anyway, the purpose of the bill is it codifies common law factors that a circuit court judge must consider in making a determination as to custody and parenting time in child custody cases in Maryland. It basically puts all of the case law, the common law, in one place in the annotated code. Right now, we're having we were unable to get the data number of individuals that represent themselves, that they go pro se. There are self-help centers, but quite honestly, they're not allowed to give legal advice. So they help people with the forms, how to fill them out, but the bottom line is they can't give them legal advice. So the bill is proposed in conjunction with Maryland Rules 9-204.1 and 9-204.2, which were approved by the Court of Appeals in September 2019 and became effective in December 1st, 2019. The new rules require the parties in a contested custody case to submit to the court proposed parenting plans to the court prior to the onset of any custody trial. Rules provide for improved procedural consideration, a list of factors for the parties in the court to consider in making a custodial determination in the best interest of the parties involved. Tracking the new implementation of the rules, 1168 proposes the use of neutral positive terms such as decision-making authority and parenting time in place of custody and visitation, so that it puts the focus back where it should be, on the children. The 15 factors the court are to consider in the decision-making and parenting time determination are listed in HB 1168 and are those that are entwined in multiple Maryland common law determinations. HB 68 has been worked on very hard, but it is a no-brainer when it comes to family law and the best interests of the child. Please vote favorably for HB 1168. Thank you very much.
Thank you. Judge Dumais, go ahead for 2 minutes.
Thank you, Mr. Chairman, and it's nice to see everyone again. And I'm happy to be here on this bill. I appreciate the fact this committee actually did vote this bill out of committee and through over to the Senate last year, and I hope they'll do so again. As Delegate McComas indicated, this was the result of a commission, and I wanted to tell you a little bit about the commission, which was actually Delegate McComas's bill. The commission had about 30 members, but over the course of the 2 years or 18 months actually that the commission met, we probably involved over 200 people. So we involved people from all sorts of parents groups on both sides of the issue. We did divide into committees. One in particular developed this statute. Another one is actually the one that developed the parenting plans that are now in the rules. Now that I'm sitting on these cases, I would say about half of the custody cases that I've heard since December 3rd when I started really are it's self-represented individuals, and they're not sure what to present. And I'm not saying that this is a panacea, but if we had something in place that we could hand to them and say, this is the statute, these are the things the court's going to review to make a determination. What I think the most important piece of this bill, Delegate McComas touched on, is really changing the dynamics of custody determinations by using more neutral and positive terms. It is about what's best for the child, but importantly, it's also about changing the dynamics so that people think about parenting time and not necessarily who has custody, who has visitation. I have always hated the word visitation, and I've said this multiple times to this committee. I think it is about parenting time. It's about access and decision-making authority. It's not about who gets to make the decision. It's really what's the best way to make the decision for the child. We need to change the dynamics. And I'll tell you, I had a case, a 3-day case this week, and it was the initial custody order was from Illinois. They're a little bit ahead of us. It's an awkward term, but their custody term is an allocation order, so that they have already gotten rid of sort of who has custody and who has visitation. So I would be happy to answer questions online or offline, and I hope that you'll get this bill through today, and I'm going to go talk to the Senate shortly. Thank you very much for your time.
Thank you. We'll hear from Lori Ruth and then Michelle Smith. So Lori Ruth, please, I'll give you 2 minutes. Go ahead.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I want to thank Delegate McComas for bringing this bill again, and I'm delighted to see Judge Dumais, the first time I've said that out loud to her, here testifying. I also served on the Custody Commission back in 2013 or whenever it was now, and I don't want to repeat anything they have said, so I will just say that from our perspective, operating the Family Law Hotline, which I started on in 2006 and still take shifts on from time to time now, custody is the #1 question and always has been for self-represented litigants calling that line for assistance. And I just can't emphasize enough the point that if there was something to point to, it would help self-represented litigants understand what the court is actually looking for when they bring these cases to them. So it's not about he hates my spaghetti and you know, I always wanted to give the kids no sweets and he wanted to give them sweets. It's these really factors that have developed over case law over the years. And I just think this would be a tremendous boon to the citizens of Maryland and actually to the judiciary as well. And so for those reasons, we urge a favorable report. Thank you.
Michelle Smith, please, for 2 minutes.
Thank you, Mr. Chairman and Vice Chairman, members of the committee. And thank you very much, sponsor McComas, Henson, and McKay, and hello, Judge Dumais. I am Michelle Smith. I am here on behalf of the Family and Juvenile Law section of the Maryland State Bar Association. We urge a strongly favorable report for House Bill 1168 for all of the reasons that Delegate McComas said, Judge Dumais said, and my predecessor from the House of Ruth, Laurie. I'm sorry, from the Women's Law Center, Lori Ruth. I think the House of Ruth is also going to testify in favor. This bill, just to highlight a couple of the points that were already made that we agree with so strongly. This bill, House Bill 1168, the codification of the factors that are well-settled law and heavily researched by the commission would be extremely critical for self-represented litigants in the family law context so that they actually know what the custody factors are. They know what evidence they need to bring to court. They know what arguments they need to make in order to promote their side of the factors. There is no place in the statute other than this bill that lists those factors, and it is critical that we have them listed. I also agree strongly with Judge Dumais' emphasis on changing the tenor of the discussions between parents who are in custody disputes, as well as with the judiciary, changing these terms, which have already begun. So this statute is critical for that reason too, because otherwise we don't have consistent terms in the statute. Changing parenting time, legal decision-making from the previous terms that were a little bit less soft and equal with regard to parents' time with their own children is critical to changing the paradigm and the dynamics that occur in some of these cases. So for all those reasons and for the children who are in these battles, in the middle of these battles in court cases, we urge a favorable report for House Bill 1168. Thank you very much.
Has Dorothy Lennig been able to join us? Okay, we're going to take questions for this panel then, and then we will go from there. So are there questions for this panel? Seeing none, we thank you all very much for your testimony today. We'll go to the one person testifying in opposition, and that is Vince McAvoy, please. Mr. McAvoy, you have 2 minutes.
All right, thank you so much, committee. This is a perennially bad bill. I'm trying to kill all the audio that I have coming in. And I urge an unfavorable on this bill. This has garnered an unfavorable from JPR in the past. It goes the bus long enough and to recall the process. Jill Carter actually started this with Delegate Alston, I believe it was, to review equal parenting time. That's how this came about, because year after year, fathers were coming into Annapolis and explaining that they were having disparate treatment, biased treatment. You just heard that in the previous bill. This is what's going on still to this day. Now you have a judge chiming in who actually should just be leaving the scene, has to come back. Okay. Incidentally, we've had this bill withdrawn because of ethics issues when this thing was filed. This is its 7th or 8th redux. I urge an unfavorable because this was promoted by Jill Carter. It got hijacked, and then people who were in the industry, some of whom testified just now, are advocating for financial interests, never for the father, never for the child and the family in totality. It aims to place children's rights above parental rights. This isn't just not the law, it's just not the precedent. It's not even helpful to the situations. And what it does is helps perpetuate the maternal preference that we had indoctrinated in this state until 1973 throughout. All the parents that came, there weren't really many groups. There was my group, National Parents Organization. The parents all to a person all said they wanted 50-50 equal parenting time. There were no handouts or anything. This is just a natural grassroots understanding of how parenting should happen. What you have is industry insiders who make money off this. And when they say that no place is this iterated, you can't tell people what to do in pro se. I've made these forms when I was in child support and helped people get further with this. We absolutely could be helping these parents more,
Mr. McAvoy.
except for money. Okay, so again, I urge unfavorable. I'll send you something because this is 10 years ago, this commission ran.
All right. There's a question for Mr. McAvoy from Delegate Davis, please.
Thank you, Chair.
Thank you, Mr. Chair. I just have a comment for Mr. McAvoy. He is always welcome here to testify, but he has to do it respectfully. That is Senator Carter.
Oh my God, did I say, oh, I am, oh, please don't let her know. Please don't. Oh my God, did I say that?
Are there further questions for the panel?
When she introduced it, it was delegate.
Are there further questions for the panel?
Oh my.
All right, seeing none, we thank you very much. That concludes the testimony on House Bill 1168. We're going to go to House Bill 1178. And this is also from Delegate McComas. We're going to hear from Delegate McComas and Darlene McLaughlin, please. This is a 2-in-1 bill, so 2 minutes for Delegate McComas, 1 minute for everybody else. And we will start with Delegate McComas now for 2 minutes.
Could I just, I need to tell Darlene she's got to testify. If you just give me a second. So she knows that.
All right, 1 moment, please.
1 second. Hey, Darlene, you're going to testify for the control. Right. So, well, I can. Well, I'm going to introduce and then just come in when I say come in. Yeah, I'll have it set up, so don't worry about it. Thank you, Mr. Chair. I think we're set.
Go ahead for 2 minutes. That's fine.
All right. The Duluth Domestic Violence Power and Control Wheel is a great tool to help victims of abuse to understand power and control dynamic. Although the perimeter of the wheel represents those forms of abuse, physical and sexual, which seem to be the most often in the public eye, the inner workings of the wheel outlines the many forms that abuse can take. For those suffering from coercive control, control is at the core of the abuse cycle. More to the point, the strategies and methods abusers implement are among the spokes that represent the victimization of those who have lost their ability to live without fear of reprisal, domination, intimidation, isolation, economic and emotional abuse. Coercive control robs the victim of their power to make decisions about something as simple as what to wear, how to talk, and what time to go, and from daily activities. Life for the coercively controlled abuse victim gradually becomes so confining and manipulated that the abuser has all power over them. The victim has no personal freedom whatsoever. The home, in fact, becomes a form of confinement and isolation from others, a prison for the victim to be kept under control. Victims of coercive control often have no physical signs of abuse. They frequently don't have bruises, cuts, or broken bones. They are told when, how, and why to do something. Sometimes their food is withheld because they did not comply with some controlling edict. Their activities on the phone or computer are thoroughly scrutinized and sometimes cut off completely. Email, text, and social media are often forbidden as it represents an avenue of communication with the outside world the abuser cannot fully control. They simply have no autonomy. Imagine living that way day to day. Someone tells you how, when, and where you can go, and if you fail to follow the edicts, there are severe consequences. Control is the key here. No freedom of expression, freedom of thought, or self-determining actions. The very civil rights we have as individuals are stripped from the abused and replaced with the agenda of the abuser. Personal freedom belongs to the abuser alone. However, given the many manifestations of control, the current amendment to HB 1178 gives the court a beginning list of what constitutes coercive control. It's attached to my testimony, which has been forwarded to the committee, so that the meaning is narrowed and more defined. The amendment language is, as implemented, is taken from a Connecticut statute that was enacted in 2021. HB 1178 recognizes domination and control of the victim through coercive control that strips the abused of their ability and freedom to make self-effectuating decisions. HB 1178 recognizes coercion as a
You muted yourself. Delegate McComas, you muted yourself.
all right.
Just for the last two sentences, you muted yourself, and then go ahead and wrap up and we'll hear
Okay.
from Ms.
HB
McLaughlin.
1178 recognizes the domination and control of the victim through coercive behavior and strips the abused of their ability and freedom to make self-effectuating decisions. HB 1178 recognizes coercion as abuse and gives the victim an outlet to seek escape from the controlling behaviors that rob them of their own self-will and provide them with a path of escape from their abuser. Please pass HB 1178. And just remember that the definition of coercive control should be with my testimony. So with that, I turn it over to Darlene. For
All right,
1 minute.
we'll give Darlene a chance to
Yes.
get in there and settle in for a
Hi, you all know me as Delegate McComas' aide. I'm also an attorney, but I'm also one of these victims, and so was my daughter. She learned to live that way. She's at the time was in her 40s. She thought that that's the way things worked because when she left home, that's the way I had to live. I had to answer for where I went, how I spent money. If I was seen on the road going somewhere and I hadn't disclosed it, it was discovered, and I or my children suffered consequences. If I was running an errand for one of them, they were punished. It became so fearsome that it was the end of a long marriage. I couldn't exist that way anymore. I wasn't allowed to go to school. I wasn't allowed to learn things. I wasn't allowed to expand my knowledge. It was after that I left or cut off the relationship and spent $48,000 to get a divorce. And it was the hardest thing I've ever done because in that 4.5 years, it cost me the relationships of 2 of my children. It took me 7 years to rebuild because they believed that I should, and I quote, "Mom, you need to listen to what Daddy tells you to do." And they were only in their early teens. So, I mean, there were consequences such as I wouldn't be allowed to go to church, or I couldn't take the kids to see their grandfather, or I couldn't wear certain clothes because he didn't like me to wear those things. If I did, he would destroy things. He took a bolt cutter to my computer when he found out I was actually accessing the internet to try to take classes. So this is a lifestyle that my daughter, her testimony is here as well. She witnessed and didn't understand fully, and in going to college and getting away from the knowledge or the thought that men are in control and that I have to listen to someone. This is the way we live, and we need to pass this bill. Thank you, committee.
Thank you very much.
Thank you.
Are there
I'm
questions?
going to give the chair back to the delegate.
Okay. Are there questions for Delegate McComas or Ms. McLaughlin?
I'm still here if we have.
Who is still there? Delegate Davis, I believe your hand is still raised from before. Yes, okay. That's fine. Anyone else with a question? Delegate Juanita Fisher, please.
Mr. Chair, this isn't a question, but I just did want to thank Ms. McLaughlin for sharing her story. And I know that's very difficult and we appreciate it and it takes courage.
Thank you. Not the amount of courage that it took me to get away from him. You have no idea. I mean, literally, I'll tell a big story. I was warned that if one day I came home and I had been to the laundromat, I was forbidden to go out. And I had children in cloth diapers and I was washing clothes by hand. It was winter, my hands were split open. And he told me that, we had a farm, 56 acres at the time. He says, if you fall into the hog pen, all they'll find is your teeth. That was a veiled threat, and I took it very seriously.
All right. Are there further questions from the panel? All right. Seeing none, we thank you very much. Thank you both very much.
Thank you for your time. Thank you.
Thank you. There are 2 people signed up in opposition. One is Vince McAvoy and the other is Melanie Shapiro. They are coming in the room. I see Mr. McAvoy. Go ahead for 1 minute, please.
All right, thank you so much, committee. We've heard this bill before, and I just want to say that what probably Melanie's going to say, which is basically that it's overly broad. No one likes bullies. We see that all the time. But we have legislation about that. That's not what this is about. This is an issue about whether or not this bill could be used as to whether or not someone's going to IHOP versus whether they're going to Ruth Chris. The controlling coercive issue is just way too broad. There are other domestic violence bills that get to the point. And I guess I would ask, every year I tell Delegate McComas's aide, I'm sorry that you went through this, but honestly, when you're dancing, who's leading? Somebody's got to lead. You can't both lead. So that's the issue that you have as you apply this from a policy level to other people. Obviously, they had an issue. I guess they resolved that issue, Darlene and her husband. And no offense to Delegate McComas, but I asked her to withdraw because it's the same issue, it's the same bill, it's the same problem, that it's too broad. You can't equitably apply it to all people. Other people are going to have problems. I guess,
Mr. McAvoy.
Just in wrapping up, I would say, look, we have Maryland case search. Before you go and get married, look into it. See if that's the person you want to live the rest of your life with. Urgent unfavorable. Thank you so much.
Melanie Shapiro.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. I am here testifying in opposition to House Bill 1178, and I want to first recognize how very real coercive control is for victims of domestic violence. I appreciate Delegate McComas's aide coming forward and testifying regarding the coercive control that she did experience and the sharing how she has survived, and she is in fact a survivor. However, this bill would add coercive control to the protective order statute, and that is of concern. The Better Women's Justice Project actually released a report in the fall. They had a series of listening sessions and looked at coercive control in the context of protective orders, in the context of criminal law, and in the context of family law. And there are still a lot of concerns about how this could disparately impact different communities and different survivors, and actually be a tool if coercive control is added to the definition of a protective order, how it can be used to harm, in fact, survivors. There is, in fact, conversation right now on a definition for Maryland rules regarding coercive control in the narrow context of mediation for families going through the divorce proceedings, and saying that if there is coercive control, that they do not need to go through mediation. However, protective orders offer a tremendous amount of protection, and it should be limited to physical abuse and threats of physical abuse. So for all those reasons, we are opposing House Bill 1178.
Are there questions for this panel? Seeing none, we thank you very much. And that concludes the testimony for House Bill 1178. We're now going to go to House Bill 1142. Delegate Attar, who is going to be joined by Robin Phillips, Lieutenant Commander Bartness from the Baltimore Police Department, and Councilman Yitzi Schleifer from the Baltimore City Council. If we could have them brought into the room, that would be great. It's a 2-in-1 bill, 2 minutes for Delegate Attar, 1 minute for everybody else. So Delegate Attar, go ahead.
Thank you, Mr. Chairman, Mr. Vice Chair, and members. For the record, I'm Delia Attar, here presenting House Bill 1142, Juvenile Offense Database. Several years ago, I worked as a prosecutor in the Baltimore City Juvenile Justice Center. It was an extremely emotional and eye-opening time in my career. It became clear to me that we are doing wrong by our children. Day after day, I would see children going in and out of the system like a revolving door. Our children, our future, are coming out of the juvenile system worse than when they went in. We are not properly rehabilitating these children. There's a lack of transparency in the system. How are we to ensure children are being rehabilitated if they're being kept in the dark? House Bill 1142 creates a database that provides a general description of any judicial or other action taken in relation to a juvenile alleged to have committed an offense. I want to be very clear about this. It is extremely, extremely important that we protect the identity of these children. That is not up for the debate. The bill expressly prohibits the database from including any identifiable information about the juvenile, including name, age group, race, address, and any known alias. We must do right by our children. Transparency is crucial in the process, and I therefore ask for a favorable report. Thank you.
Thank you. Robin Phillips, please, for 1 minute. Not sure if we have Robin. No Robin, okay. Do we have, yes, we do. The Lieutenant Commander from Baltimore Police Department, Bartness, please.
Good afternoon, Chairman Clippinger, Vice Chair Moon, and members of the Judiciary Committee. I'm Lieutenant Colonel Martin Bartness. I'm the Deputy Chief of Patrol for the Baltimore Police Department, where I have served for 25 years. Over the past year or so, BPD commanders have worked with our public information and government affairs teams to consistently provide the public and elected officials with timely updates on arrests for high-profile crimes. We also host monthly meetings in all 9 police districts where we provide crime statistics, updates on the implementation of the consent decree, and ways we can partner to prevent and solve crime. An issue communities ask us about frequently is crime committed by youth, especially violent crimes such as carjackings and shootings. Residents, media, and elected officials alike want to know if we have arrested the suspect, if the suspect is back on the street, how quickly the suspect was returned to the street, and the punishment received if found guilty. While we can and do provide limited information about the arrests of youth, we cannot answer many of the questions posed to us. That is why the BPD is supporting House Bill 1142. We believe the proposed database would provide the public with important insight into crimes committed in their communities. Moreover, it will create public understanding of how youth interact with the criminal justice system, the types of sentences youth receive, and whether or not prescribed interventions are having the desired behavioral effects. This transparency supports our collective goal of ensuring youth offenders get the help and services they need to avoid recidivism and become productive citizens. It should be noted this bill expressly forbids the release of any identifying information regarding a juvenile's name, age, race, address, or known alias. This confidentiality provision properly balances the public's desire for information against the need to protect a youth's identity, as the last thing we want is to negatively impact a young person's future ability to seek employment, education, or housing. Thank you for allowing me to comment on this important piece of legislation.
Thank you very much, Councilman. There you are. Go ahead.
Thank you so much, Chairman Clippinger and members of the committee for allowing me this opportunity to testify in support of this bill. I want to thank my hardworking delegate, Dalia Attar, for introducing this bill. Juvenile crime is an issue that is affecting Baltimore every day. We hear from parents of these juveniles that adequate resources are not being provided to rehabilitate their children, and they are begging for help. When it comes to adult crimes, we can see and measure the success of re-entry and rehabilitation programs. When it comes to the non-transparent juvenile system, we have no idea what happens other than that we see the same violent juveniles are reoffending. We know that the best time to course correct is before these kids become adults and have permanent damaging records. Bringing transparency to what's working and not working in the system without compromising the identity of the juveniles is a win-win to protect the futures of these children and the public's safety. And for those reasons, I urge the committee to vote favorable on this bill. Thank you.
Thank you. We'll go to Delegate Cardin, please.
Thank you, Mr. Chairman. Thank you, Delegate Attar, for bringing the bill. And it's always good to see you, Councilman Schleifer. This question actually is for Mr. Bartness, or Lieutenant Commander, I guess, Bartness. Thank you so much for being here and for your testimony. What is there something in the law that prohibits you from publishing the non-confidential information, and then we have to change the law for you to do it? So, or are you just want the state to tell you that you have to, so that you can give a reason for why you can then publish it?
Thank you, Delegate. What we believe this particular bill does is provide the public a platform to readily access this information at their fingertips, which they currently cannot do.
But is there anything stopping, for example, either the police department or the council or the administration from saying, we want to create a web page that provides this information, and we're asking you to And we're asking the department to just give us the information, or do we need to put this in law, or can we send a letter saying you need to start doing this?
So I think because this is a fairly complex multi-agency criminal justice system issue involving multiple partners, this provides a mechanism for us to provide that in a timely manner that does not currently exist.
Delegate Juanita Fisher.
Thank you, Mr. Chair. Delegate Attar, thank you for bringing this legislation. I have a question. I think his name is Delegate Clippinger, I'm not sure, had a bill on juvenile justice reform, and this committee's done a lot of work in that. How would this bill support or address that? And are there any juvenile experts that say having a compiled list of this information would actually help the outcomes for the juveniles themselves versus the community just having access to the information?
So thank you, Delegate Fisher, for both questions. I'm going to answer the second one first. Transparency in all forms of government, I think, is crucial. And I think we see that in any types of government, when there's transparency, we have better outcomes because then the public is able to see what's happening. And many times government does things differently because of it. And I can give an example as a prosecutor. Sometimes there are judges, this is an adult court, who are just letting violent criminals out one after the next. And then all of a sudden you see newspaper sees that and brings it up, and that same judge just stops doing that and realizes, oh wait, I got caught, and stops doing it. So I think transparency is important in general. In terms of Delegate Clippinger's bill, I actually believe right now this is the most important time to bring a bill like this because of the Juvenile Justice Reform Act. We're moving in that direction of trying to make sure we're rehabilitating children and only locking up the most violent offenders and only for the appropriate time. So a bill like this will let the public see whether it's working, it's not, if we need to come back in, fix anything, or what more can be done. So thank you for the question, Delegate.
I would just follow up on that. You know, these are people's children. And I think anytime you want to venture into information about children, it's quite complicated. I think we saw that with a couple of bills we had on the floor already. And so I'll be taking a deep look into it, and I appreciate your work on this, though.
I appreciate that, Delegate, and I agree. We have to make sure that this bill does not let anyone's information become public. Thank you.
Delegate Cox, then Crutchfield, then Grammer.
Delegate Attar, it's good to see you, and thanks for your concern for the youth. I mean, I totally agree with you that it is probably one of the number one issues in our state for our future generations. It's heartbreaking at times. Real quick, and forgive me if I missed this, but what other states do this?
I do not have any information on whether other states do it, but I can follow up and find out if there are.
Okay. And what is the purpose, since we all agree that juvenile information needs to be kept private? How would this benefit anything, particularly considering I'm all for transparency. I'm with you on that. I just wonder if somebody knows that something happened in their neighborhood and they can do a search for similar incidences during that similar times. Do you have a mechanism that can kind of control how that's accessed, and what would be the overriding purpose to help youth in this regard? How would this be a tool that we can use?
Thank you, Delegate, for that question. So a couple of things. First, if we have this in place, we're able to track down. We're not trying to track the youth. We're trying to track, okay, so someone commits an armed robbery and they're put into this program, and did that program help, or are we seeing repeat offenders and this happening over and over again? So we're able to track more so on the rehabilitative side what's happening with children. And I'm sorry, I forgot your other question. Can you repeat it?
I've forgotten it as well.
Sorry, I wasn't taking good notes.
No, I think I was just wondering how are we going to protect the information when individual neighborhoods could kind of search for certain types of incidences at certain times?
Thank you for that question. So I actually have been in discussions with several people about that. And a suggestion that I had mentioned that may be possible is to not necessarily, right now it would be live and it would be right on the spot. So to not necessarily have the information go up right away. And that would be a possible amendment that I'd love to discuss with the subcommittee, that rather there would be some form of delay, because we want to ensure that no one can track this information to a juvenile. And I want to make sure, and I'd love to work with the subcommittee to find ways to ensure this, because I don't want anyone to be concerned that a youth's information can be exposed. I'm a mother of 2 young children, and my children do things sometimes, and I don't want those following with them the rest of their lives. So thank you for that.
Thank you.
Delegate Crutchfield.
Thank you, Mr. Chair. And thank you, Delegate Attar. I think this is the second time you've brought this legislation to us. I guess I heard a couple of times the words recidivism and also rehabilitation. And I want to understand, because I may have lost it somewhere, how you believe that this legislation, this database, will in any way, reduce recidivism and also create or provide diversionary programs or other programs of rehabilitation for our youth.
Thank you for that question. So it won't, as is, create new programs. However, it will help us evaluate, are these programs working? And if programs are working, then that will hopefully reduce recidivism. That's the goal. So we want to ensure that our children are being rehabilitated properly. We also want to ensure that the public is safe, and there has to be the consequences side of things as well. When someone's committing murder, there needs to be consequences. But at the same time, we know almost everyone that goes in the system comes out one day, whether it's a juvenile or an adult, and we need to be rehabilitating them. I see way too often people coming out of the system, again, juvenile and adult, who is not prepared for society and then continues this recidivism problem. So we want to ensure that the programs are working appropriately, and that's the goal, one of the goals of this. Thank you for the question.
And Mr. Chair, I just have one follow-up to that, okay. With that in mind, what you just mentioned, what data have you received? Have you gone to DJS? Have you gone through their programs? Have you looked to find out what programs they have and how they are effective with youth? I mean, I guess I want to just understand kind of where you're getting your information from regarding youth programs in particular, and recidivism and rehabilitation.
Absolutely. Thank you. So I've actually been in touch with them since last year, because I filed this bill last year as well. And most recently, I received their annual report that I've gone through in great detail. And I was discussing with them possible amendments to changing that report a little bit to include additional information as some form of compromise in order to achieve the right goal. But I have been delving deep into that information, and we do see, if you look at the reports, the recidivism rates, they are high for certain crimes. And I don't have the data for you now. I can provide you with the report if you'd like, but my information is based off of that and my conversations with them.
Thank you very much, Delegate Attar. I just want to mention to you that it sounds like the data that you have is obviously data that's out there from DJS, but it's also what it sounds like you're attempting to do is what DJS already does, and that is to collect data. So I just want to put that out there to you.
Delegate Grammer.
Thank you, Mr. Chair. I think Delegate Fisher made a really important point, and she said these are people's children. And I think we all believe in a properly functioning juvenile system. I think all the comments here demonstrated that we all want a system that remediates youths that have been involved in, the misadventure of being a young person. And we don't want to ruin a person for, getting involved and just injecting them into the criminal system. So Delegate Attar, several years ago, we passed a piece of legislation that put together the Juvenile Fatality Review Team. And it's a small group of people, it's a small work group. And what this team does is it looks at the juveniles which have either died in the custody of the juvenile system or been involved in a killing. And not many people are aware of this, but I was named the delegate. There's only one delegate, and I am that delegate. I'm the member of that team. As a member of that team, we we actually go through these cases. We get access to the youth's personal history, their mental history, their family history, their criminal history. We look at the services that the juvenile justice system has offered them to make sure things are working, make sure they get access to services, to make sure they are being remediated. And there are cases, well, I can't talk about anything specifically, but there are cases where despite a long history of the system offering services and engaging the youth and ensuring they had proper educational opportunities, I have seen specific cases where despite these efforts, the youth continues to demonstrate a course of conduct that is escalating, which ultimately leads to their death. Now, it sounds like that's terrible. We want to fix that, but it sounds like the purpose in general of your bill, putting the small details that we could debate aside, that the purpose of your bill is to look at the issue on a broad statistical level and say, are there places where we need to look and in a broad scale and say, is this working? Are the things, despite the structure of the system, is there something we need to change? Is there something that's failing? Is that generally what you're looking to get at here?
Yes, it is. Thank you for the question, and thank you for providing all that background information. I was not aware of the commission. I'd love to follow up with you about it, but yes, that's correct. Thank you.
Yeah, so I'd be happy to talk with you about that. I do have one more question for the law enforcement gentleman. I want to ask Delegate Cardin's question in a different way. If I were to send you a PIA requesting this data, why could you not already do this? What is legally prohibiting you from offering this?
The Baltimore Police Department does not house the data. It's housed by the state and DJS.
But you have access to the data, if I'm not mistaken.
We have access through DJS.
So
in some cases direct, and in some cases through a request ourselves.
Could we if we were to PIA the juvenile justice system, could they procure this? What is legally prohibiting us from getting this if we wanted it?
I'm not an attorney, so I can't answer that question.
I'm just trying to get at Delegate Cardin's, I think, general bigger point is there something that's precluding us, or are we just looking to create an efficient way to collect this information? But we'll have to follow up after the hearing. I appreciate
Delegate Grammar in the bill. It quotes part of the Courts of Judicial Proceedings article, the 3-8A-27, that says the police record concerning a child is confidential and shall be maintained separate from those of adults. It's a well-held sort of maxim of juvenile law that a juvenile's record is sealed and confidential, and so that's kind of throughout that part of the court's article. But I'd commend that to you to take a look at, and then we can go from there.
All right, thank you, Mr. Chair.
All right. Seeing no further questions, thank you very much. I believe there's one person here to testify in opposition, and that's David Shapiro. Oh, I'm sorry, wait a minute. Let's see if people are still here. Did I lose them? I think I lost them. Delegate McComas, I'm sorry, I think I lost them. We moved on.
Can I just ask one quick question you may know?
The sponsor is still here. You can ask the sponsor.
Oh, okay. Sorry, Delegate Attar. On pre-sentence investigation reports, if the person is found guilty of a crime, and let's say it's assault in the first degree, and they're doing a PSI, can they get into their juvenile record when they do
So juvenile record is completely protected, but they can petition the court and ask them to release it. But without a petition and the court granting it, the information would not be released.
Okay, so it's not standard.
No.
When the judge orders a PSI, but the judge could say, I want a PSI and I want to get the juvenile
I'm
information?
assuming you're referring to a PSI of an adult, someone over 18.
Yes, right. The
Yeah,
PSI.
no, it's not automatic. The information is not automatic. You would have to petition the courts for that information.
So the prosecutor would petition the court. in that
Absolutely,
case.
yes.
Okay, all right, thank you.
Sure.
Because I've seen it, that's why I just kind of wondered. Okay, thank you.
All right, now we're going to the opposition. We thank you very much, Delegate Attar, and we'll hear now from testifying in opposition. I think it's David Shapiro. Mr. Shapiro? Maybe no Mr. Shapiro. Oh, there he is. We'll hear from you for 1 minute, please. Go ahead.
Yes, good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is David Shapiro. I'm an assistant public defender in Baltimore City. Just as when this bill was introduced last year, we urge an unfavorable report on House Bill 1142. Our juvenile justice system, as you've all been discussing, intentionally shields respondents from the public eye. This bill would create a central database for all to see without any context. In my work as an assistant public defender, I am our office's point person for juvenile expungements, and I've come to understand that firsthand that unfortunately acts committed as a young person are impossible to break free of. I've had young adults who come to me with no fact-sustained findings. That's in adult court, that's a guilty, so no guilty findings. I've had individuals who didn't do what they were accused of, and they face barriers to employment, to joining the military, and the law as it stands makes it an arduous process to even attempt to remedy these issues. This bill would make it even harder. We look forward to working with members of this committee to improve many aspects of the juvenile court system, as you have been doing, but particularly confidentiality aspects. And we want you to help. We want to help you promote the success of all Marylanders, especially young people. I have submitted our written testimony, and I'm definitely open to questions. I know that there are a lot of different questions from different delegates.
Here come two of them, Delegate Eric and then Grammer.
Thank you, Mr. Chair. Thank you for being here, Mr. Shapiro. Could you just explain a little bit more? Because what we just heard was that, and what I know to be true is that these juvenile files are sealed. So if my child did something and their files are sealed, how could that become a barrier to employment?
Yeah, so the police records, unfortunately, are automatically submitted to a national database. And so the military has access to them. But the more that we create these databases that are either private or public, and the more information that's out there about certain incidents, the easier it is for people to categorize and catalog different folks. I think that we should be going in the realm of fewer databases rather than more, especially when it comes to young people. Because once something is out there, once a private entity has that information, there's nothing in the law that prevents them from disclosing that information to anyone, unfortunately.
So, well, this database, I'm sure you read the bill, is de-identified. So there is no name connected to the information. And you probably heard, and I know there wasn't a lot of people who have spoken specifically to the victimization going on, but the community that the sponsor represents has had some atrocious crimes committed by juveniles, and the community is, obviously concerned about a trend. And this bill is more about transparency than it is about, penalization of any kind. It's really just allowing the public access to what is happening in their own community, not who specifically is doing the crime. This is certainly not going to be a barrier to employment. It's not going to be stigmatizing to the juveniles. It's telling the surrounding communities, we know that you're scared. We know that there's crime happening and it's hurting the community, and allowing them to visually quantify and see what is happening. But I'm confused why the position of OPD is unfavorable when there is no identifying information connected to these crimes.
And again, I would say it's the ease of having that identifying information connected to them. We call it Smaltimore for a reason, right? When these incidents have a lot of people paying attention to them, when there is outcry in communities, that's when more information is divulged without anyone intending it to do so. But I would note that in this bill, we're talking about committed the offense, it's alleged to have committed the offense. These are things that are not necessarily proven true in court. And then it's about whether that person was referred to a diversion or treatment program. So then we have that information. about what's going on. Any prior offenses. So all of a sudden, this unidentified individual is connected to prior offenses. The location, the date, a description of the offense, which is not exactly specified how descriptive it is. But all of these things can be used by anyone on the internet in this age of doxing, when people's information is free flowing to target specific juveniles, especially when we have that information already in data form in the data resource guides provided by DJS. And DJS is telling us, and all that information that we have is telling us that actually recidivism is down. We're not having these crazy incidents more than ever before. And in fact, we're having them less.
I would certainly
now
take
than
issue
before.
with the comment that it's less. I think data shows that juvenile crime is absolutely not less. Maybe recidivism is going down. I have not seen data on juvenile recidivism. I'm not sure we can get it since we're not allowed to look at it. But
we do have juvenile arrest data. It is down. It is down the last 10 years. It's down year over year.
Arrest data is not what I'm talking about. I'm talking about crimes being committed. Yes, that is a huge difference. I agree. The arrests are absolutely down, but I thank you for answering my questions. Hopefully OPD could come back with some constructive ideas about how we can address juvenile crimes, which are terrifying some of the communities in the Baltimore metro area.
Thank you.
Delegate Grammer.
Thank you, Mr. Chair. Mr. Shapiro, so let me ask you a more broad philosophical question that relates to the bill. If the system is failing to remediate people, if we do see examples and increasing examples of the system failing to defer people from the course that they're on, is that serving youth? If you can demonstrate that there is an escalating course of conduct, and there are many examples where the infractions of a youth are not getting better, they're actually getting worse, they're getting more violent, does that serve the youth?
So again, I would say we see recidivism as down, but I would also say that if we're focused on the worst of the worst, we're ignoring 99% of the young people who are being rehabilitated in this system. Those don't make the flashy headlines. And so what we see is just actually a cycle of people focusing on the worst of the worst. And that database would only highlight that and would get people, I think, more scared of kids that they don't need to be scared of. We should be focusing on investing in programs and investing in mentoring and counseling and therapeutic programs, evidence-based programs, but not in creating databases that I think would increase fear.
But to Delegate Arcon's point, arrests are down, which means young people don't go into the system. And subjectively, that's good, but that's also never recorded. If charges are dropped, that never registers in a lot of places. And this is all in a system where, frankly, 99% of the public, 99% of this body have absolutely no clue what's going on. And if you work with local law enforcement, I mean, the stories that are coming out of Eastern Baltimore County, we have carjackings where the youth is back out on the street the same day. So there's a bit of, and I think this gets to the broader concern of the bill sponsor, is that when we say like recidivism is down, when we say there are less arrests, yeah, there are less arrests, maybe, but doesn't mean there's less crime. When we say there's less recidivism, maybe that's in a lot of cases because charges dropped. If there are less guilty findings, the way that demonstrates in the statistics, we could look at that one way, but that in the totality of it, it really doesn't mean recidivism is down. It just means at one point in the system, a youth that is experiencing an escalating course of conduct is just outside of any public purview at all. And it's getting worse. And, you know, if we took some of this,
isn't that so in our future?
No, I actually do have a specific question.
Let's get to a specific question. Let's go.
Would you be willing to work with the bill sponsor to maybe come to work out a way that we can kind of get at that, to get to that bigger point, to really try and identify statistically on a broad scale, are there failures in the system where we just have these failures of the system to stop recidivation? I mean, isn't that what we're all going for? Would you be willing to work with the bill sponsor to work toward that if we have problems with the bill as structured?
The Office of Public Defender is, of course, ecstatic and happy to work with any bill sponsor who wants to make lives better for all of our clients and make systems that are improved, make programs that work and are effective. Yes.
Well, that's at least an opening. I appreciate the time.
Thank you.
Thank you. Are there further questions for this witness? Seeing none, we thank you very much. And that concludes the testimony on House Bill 1142. We're going to House Bill 1344 now, and Delegate Bandari. I'm going to hear from Delegate Bandari, Joshua Greenberg from Laxman Adhikari, and Shyam Adhikari. We'll hear from all of them. It's a new bill, so 3 minutes for Delegate Bandari and 2 minutes for everybody else. 3 minutes now for Delegate Bandari. Go ahead.
Thank you, Mr. Chair and members of the Judiciary Committee. For the record, this is Delegate Harry Bandari from District 8 in Baltimore County, here with House Bill 1344, work group to study extreme risk protective orders, the Sagar Ghimire Act. By all accounts, Sagar Ghimire was a bright young man with a promising future. It's an aspiring data scientist who had just graduated from Claflin University in South Carolina. Sagar moved to Baltimore County last year in hopes of attending graduate school. While settling into a new home in Woodlawn, Sagar was killed in a shooting by a neighbor with a history of erratic and violent behavior. He was just 24. I was devastated when I heard this news and rushed to the scene to offer whatever help I could. My grief at the funeral and afterwards was nothing compared to what his family felt as they gathered to mourn Sagar's passing. In the days and weeks which followed, there was one thing they wanted: justice. The perpetrator had long been on the radar of our law enforcement. Neighbors reported that he often confronted them, accusing them of spying on him. One resident who had registered concern to the police told the Baltimore Sun that the situation was like a ticking bomb. Tragically, Sagar was caught in that blast, and his family was left to wonder why, if the clues were there, was no action taken, which might have prevented this incident. I put this question to our local law enforcement as well as to our Baltimore County State Attorney and County Executive. I could not get a clear answer. This bill would take a step toward providing that answer. This bill will give us the tool to more readily pursue justice for all the victims of this incident, and it stops such senseless violence from ever occurring again. It will help us build on the ERPO's legislation to ensure that our neighborhoods are kept safe and that the vulnerable people in our communities get the care and attention they need. In light of all this, I request a favorable report, Mr. Chair.
Mr. Greenberg, please. Joshua Greenberg.
Yes, sir. You can hear me?
Yes, for 2 minutes, please.
Fantastic. Well, good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Josh Greenberg, and I'm here to testify on behalf of Baltimore County Executive Johnny Olszewski in support of House Bill 1344. When individuals present a clear, imminent danger to the community around them, extreme risk protective orders serve as a final option to prevent potential tragedy. Petitioners undergo a rigorous process to ensure that only those individuals who truly pose a risk are subject to the requirements under ERPO law. These petitions serve as a last line of defense against incidents of tragic violence, and it's vitally important to ensure that the system works effectively and as intended. When it comes to the safety of our communities, no amount of preparation is too great. This legislation would establish the work group to study extreme risk protective orders and would evaluate the effectiveness of ERPO's throughout the state and make recommendations for ways these initiatives can be improved. Thanks to the work done by the General Assembly and members of this committee, the state of Maryland has led the nation in finding innovative strategies to prevent mass tragedy from occurring. The county asks that we continue to find more ways to get our residents the help they need before it's too late. House Bill 1344 is named after Sagar Gimire, a young student who was tragically murdered on May 8th, 2021, during a mass shooting in Woodlawn. Baltimore County grieves with Mr. Gimire's family and families of all the victims. Accordingly, Baltimore County requests a favorable report on 1344, and I'd like to thank Delegate Bandari for bringing forward this important legislation. Thank you. I'm happy to take any questions.
Thank you very much. Laxman Adhikari, and I apologize in advance for if I did not pronounce your last name correctly. We'll hear from you now for 2 minutes, please.
You did good job, sir. Dear Chair and esteemed members of the Judiciary Committee, good afternoon. I'm Laxman Adhikari, representing the voice of Sagar Gimire's entire family here. Please allow me to read the letter from Sagar's father, who lives about 10,000 miles away in Nepal, watching this hearing right now. May the holy soul of late Sagar Gimire find peace. All helping hands be blessed. Again, these kinds of incidents not be repeated. May the government and administration get inspiration to be aware and take additional remedial measures to mitigate the brutal violence like the one my son and many sons of innocent parents had faced. What types of support can the government provide for the sake of second generation's bright star prospective Sagar memorial? I'm expecting something from the government as well. I sincerely appreciate Delegate Harry Bandari of Maryland State, Baltimore District 8, introducing this pivotal bill. May all representatives and cooperative friends show support and harmony and have peace and blessing. The family also states that we as a family members are concerned why Sagar and many other victims are forced to embrace untimely death or infliction of severe injuries for doing no wrong, despite the existence of extreme risk protection orders and red flags laws in the state of Maryland. The families of those innocent victims are compelled to be grieved throughout their lives in the same way Sagar's family is going through today. The victims' families' pain, sorrows, tears, and griefs cannot be obliterated simply through regrets and ephemeral sympathies. The Sagar family requests a favorable report on House Bill 1344 for policy recommendations and implementation to deter a future tragedy of this kind. May you all have a prosperous life. God bless America.
Thank you very much. Would like to hear from Shyam Adhikari, please. For 2 minutes, sir.
Yes, sir, I'm here. Dear Chair and honorable members of Judiciary Committee, I moved to that address like May 1, 2021 after a week on May 8 in the morning time. What happened is that we were sleeping over there, and at 7 p.m. I heard a big noise inside the house, and I was the first person who woke up at the time because I literally slept that night at around 4 p.m. because I had a few homeworks. I was a college student at the time. Right now I got graduated. And just sleeping my 3 hours, I wake up at the time. Like whenever I came outside of the house, there was no any sound. Like the earth was not shaking. There was no any earthquake. And when I went towards the parking lot, I saw there a big fire was in our house. And I told all of the members just come out of the house and just be here, like tell them to be in a safe place. And there were 4 children over there. I carried them in my shoulders and took them in another house. But my dear friend Sagar Gimire, and he was there, and he told me that we have to grab the passport documents that we have to have because we are a student there, and if we don't have the passport, then we cannot have further education in USA. And that's why he gone inside the house and bought passport and some other documents. But unfortunately, in that the documents bag he brought, my document wasn't in that bag. That's why I told him that Sagar, just go away and just be in parking lot because otherwise the fire might catch you. And I went inside the firehouse, and I was the only one at that time inside the firehouse. And when I came out of the firehouse, he was in the ground with his chest on his chest on the ground, and chest was on the ground. And what happened is that I went towards him and I saw that he was in the ground. I wake him, and there was all over the blood there. I thought he just got faint because I didn't know that, because I didn't hear any guns sounded till that time. And I just pulled his body and just brought to the grass part and just kept his head in my lap. And I just told him, just wake up, Sagar, just wake up, because he was breathing very slowly and he was trying to speak, but he could not. And I was just pressing his heart, thought that pressing his heart chest slowly will make him ease in breathing, but he couldn't. And I just told him 3 times, just wake up, Sagar. And by saying those words 3 times, the guy with a gun came in front of me and just pointed the gun in my head. At the time, I could not do anything else. And I thought, oh, that's the end of my life. Then I just closed my eyes and he just shot the gun. And immediately one policeman came there and just, he was saying that, oh, drop the gun, drop the gun. But that guy didn't drop the gun. He just ran away. And at last, like whenever I was trying to open my eyes, I thought that it hurt me a lot. And I was going through a big pain. And I saw on the road that guy was already killed. And on the other side of the road, a lot of persons, like 3-4 guys were also killed over there. And after like 2-3 minutes, a police guy came there and just he tied my thigh and after 2-3 minutes, the ambulance came there and he took me to the hospital. It's been already 8-9 months and I'm still in bed rest. I haven't been done any work. And like, even like whenever I wake, like if I sit in the ground, I cannot stand up. It might take me, someone should be there to wake me up, because this right thigh cannot give the full power to lift my body again. Even I cannot stand also, even I cannot walk for a long time, like not more than 30 minutes. I cannot walk. I should have to take rest for around 30 minutes. And it hurt me a lot. Like that was the incident. Like I cannot even forget, because I lost my friend and that even changed my life. This one now I have my right leg, I have with me, but it doesn't work properly. That's the big thing I'm just going through my life. And that's all happened that day. I cannot forget it. It was the May 8th, Friday at the morning, 7 p.m. That's all happened. That was on Saturday morning, 7 p.m. And that's why in future, I just not to have this type of crimes, because we're innocent in the community.
I know this has been incredibly difficult for you. Yeah, I would appreciate it if you could please begin to wrap up your remarks. I would appreciate it. Okay.
Sure, sir. Sure, so that's why in future, like not to have this type of crimes, I just want to pass this bill. That's why I would request favorable vote on this bill. Thank you. That's all from me.
That's fine. Thank you very much. There are questions. We'll hear from Delegate Crutchfield now.
Sure, sir. Thank you so much.
Thank you, Mr. Chair, and thank you to the panel for coming this afternoon and testifying, and especially the family being here. I know it's hard for you. Delegate Ben Hardy, I want to make sure that I understand what are the factors that are different in petitioning for a peace order versus an extreme risk protective order. I just want to make sure I understand what the real differences are between those. If you know those, you may or may not. And if not, then we can get some information later.
Josh from Baltimore County, do you want to take that question?
Yeah, sure. And I'm happy to follow up after this meeting with specifics. So my understanding is that the criteria for being able to submit a petition for extreme risk protection orders are significantly more stringent. For one thing, you can't, not anybody can file that petition against another person. Police responders, certain clinical mental health experts are also able to file those orders. To file a petition against somebody, that individual also has to be present a sort of clear and imminent danger against the people around them. That's as much as I can get into right now, but I'm happy to follow up with a sort of breakdown of how they're different.
Thank you very much.
Delegate Juanita Fisher.
Sorry, thanks, Mr. Chair. Thank you, Delegate Bhandari, for bringing this legislation forward. I was going through your bill. Your bill is a work group to look at the extreme risk protective order, correct?
Correct.
Right. And I was just wondering, would you, if the committee, when the committee is looking at the bill, if you would be open to different additions to the makeup? A lot of the people on the work group that are listed in the bill are sort of secretaries or like the directors. I think a local feel as well to the membership would be good. And I also wanted to point out to you, Delegate, that the time that you have for the report to be back is May 2023, I believe. And a lot of the appointments you have in the work group are by the governor, and we would probably have a different governor at that time. So would you be open to like a longer reporting time?
Yeah, thank you, Delegate. And I would love to follow up to discuss in subcommittee. Absolutely. I'm open to any amendment to make sure that, this bill does what it is to do.
Thank you so much.
Further questions for the panel? All right, seeing none, we thank you very much, Delegate. We thank you very much to the Adhikaris for your testimony today. And that concludes the testimony on House Bill 1344. We're going to hear now from Delegate Long and House Bill 1268. Delegate Long will testify for 2 minutes, and then there are 2 people to testify in opposition. They'll get a minute. So Delegate Long, go ahead for 2 minutes, please.
Thank you, Mr. Chair, and thank you, Mr. Vice Chair, and everyone on this committee. Here today, I'm Delegate Bob Long to testify on HB 1268, Education Reporting Arrests of Students, for the record. This is actually a pretty simple bill. This law is already an existing law, and we're just expanding it to where if any of the reporting offenses occurred that the state's attorney has to do now would also go to the Center for School Safety. The Center for School Safety is not a whole lot of people know about, but it's actually a great place to keep, how do I want to say it? It's just a great place where they keep records, and it's to keep schools safe. And we need to have this this reporting mechanism in place, because what happened was back a couple years ago, we actually had a student that was in one of the high schools that was arrested for rape. He come back into the school and he raped a young lady. Might have been 1 or 2 different ladies. I'm not sure. I won't want to be specific, but he come in and raped at least 1 student that we know of. The principal knew about it. They didn't do anything about it. And the guy was 21 years old. Make a long story short, as I always like to do, one of the concerns that I have is if these students start going from one school to another and their records doesn't follow them, it's very concerning. We're talking about some of the most some of the most offensive crimes that you can do. Weapons, drugs, assault, any related offenses. And again, it's already in law. We're just asking to add the Center for School Safety to make sure we have a safety net to make sure our kids are safe. With that, I would thank you for your time. Thank you.
Thank you very much. Are there questions for Delegate Long? Questions for Delegate Long? Seeing none, we thank you very much, Delegate. There are 2 people to testify in opposition, Mikhail Gross and Renuka Reggie. If we could have them brought in, we'll hear their testimony for 1 minute each. Ms. Gross. There we go. Go ahead for 1 minute, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth in juvenile and adult court. I'm testifying today in opposition to HB 1268, which proposes expanding the reportable offenses law. As the committee well knows, Section 70303 of the Education Article, the reportable offensive law, is one of the most extreme collateral consequences when it comes to youth involved in the justice system. It denies them their right to an education. Under the reportable offense law, students can be removed from school on mere allegations and sometimes sent to an alternative school that doesn't offer the classes that they need. such as events, placements, special education, or extracurricular activities like student government and athletics. Other times, these students are educated at home with worksheets and a tutor that they meet at the library once a week. What this bill is proposing is it's asking to essentially start a database that will follow these students around from one school to the next. Over the past 2 years, we've had parents complaining about how remote school did not work for their children. What this bill does, what Section 7303 of the Education article already does, is it essentially does that, removes those kids from school, puts them in alternative schools or on remote education, all based on mere allegations, based on a mere arrest. And what this bill would do is it would extend those arrests, that data, that information, and follow these students around from one school to the next. It's one of the last vestiges of the school to prison pipeline that is officially built into our system in Maryland, and we shouldn't be increasing the scope of who the arrest is reported to. And therefore, we would ask the committee to issue an unfavorable report.
Thank you. Renuka Reggie.
Good afternoon. My name is Renuka Rege, and I'm an attorney at the Public Justice Center. The PJC provides legal representation to students who are pushed out of school, including for reportable offenses. And we've seen how the reportable offense law is abused by school systems and can severely derail a student's education. The PJC strongly opposes HB 1268, which would expand reporting of a student's arrest for a reportable offense and related confidential student information to the Maryland Center for School Safety, the State Board of Education, and the state's attorney. The dissemination of confidential reportable offense information can adversely impact a student's education and perpetuate stigma. HB 1268 would expand reporting of not only the student's arrest for the reportable offense, but also the disposition of the offense and any time the student moves to a different county, to the Maryland Center for School Safety and the State Board of Education, creating an endless web of surveillance based on mere allegations. Rather than further invading student privacy by expanding this reporting, the General Assembly should reform the reportable offense process entirely. For these reasons, we oppose HB 1268. Thank you.
Are there questions for this panel? Delegate Munoz.
Thank you, Mr. Chair. So I just want a little bit of clarification. You two ladies are saying that it's more important for people who commit violent offenses like rape to be included in extracurricular activities than it is to protect other children from being raped. Is that what I just heard?
Delegate, I'll respond, but I'm sure that my colleague will have a response to that too. That's not what we're saying. And in fact, reportable offenses right now are most often not used for violent crime. Right now, the list of offenses for which a student can be removed from school exceeds 50 different offenses and includes things such as second-degree assault. That can be a child getting in a fight with their sibling at home. And not only could they be removed from school, what this bill would do is would ask that this reportable offense follow them around regardless of where they live. So if, let's say, this happens to a fourth grade student, this would be reported to their school. It would be reported to the state's attorney's office under this bill. It would be reported to the Center for School Safety and the State Department of Education. And if, let's say, in 11th grade, this student moves to another jurisdiction, another school system, this would still be following them around. All for an incident that was just a mere arrest that may very well not have actually even made it to court, let alone been proven in court. And so as it applies right now, the reportable offenses law is overexpansive and includes too many offenses that should not be reported. There is pending legislation to change that list of reportable offenses to limit it to violent crime. But as it stands right now, it includes quite a few offenses that are not, in fact, violent crime.
Okay, and so then as a defense attorney, would you support legislation like this if it was focused only on the most extreme offenses like rape?
So the bill that we have offered support for, I know it didn't come before this committee, would limit it to the reportable offenses to violent offenses and offenses for which a youth could be charged as an adult, to ensure that we're not catching too many students in this network of, being pushed out of school, being pushed further into the school to prison pipeline over the mere allegations. That bill would focus more on the students for which there might be a need to report that to the actual arrest of the school. But I think what it's important to note is that most of the time when you have a student who is arrested for a violent offense, they're actually removed from school already before it's even reported to the school. So at the point of arrest, a student who's arrested for the example that you gave, rape, is very likely to be detained and held pending adjudication. If they're charged in juvenile court, if they're charged as an adult, they may very well be held pending the transfer hearing or the trial in adult court. And so the offenses that are being reported right now are not actually responsive to the problem that was brought up here, the problem specifically about someone who is charged with rape going back to their same school. That's not the offenses, those are not the students who whose offenses are being reported right now. And this bill would just expand the network of the list of students whose offenses are being reported and expand who it's reported to, without focusing on on the violent offenses that actually do need to be reported that you're referring to.
Okay, so you just feel that this bill has too wide a net.
So reportable offenses as it stands right now, section 7303 of the education article, as it stands right now, has too wide of a net. And so therefore expanding that net would not actually, it wouldn't actually address the problems of public safety that the bill intends to address. And it would instead expand the reporting for the students that don't even need to be reported in the first place.
Thank you so much.
Are there further questions for this panel?
Mr. Chair.
Delegate, I usually don't let people come back after their site. If you want to provide further information, I see Delegate Grammer has a question for the panel in opposition, but we try to keep people on each side. If you want to provide further information to the committee, Delegate Long, of course, we will accept it and consider it.
Thank you.
Thank you. Okay. And now Delegate Grammer is taking a hand down. So it doesn't look like there are further questions for the panel. And that concludes the testimony for House Bill 1268. And we thank you all very much for your time and your testimony today.
Thank you.
Thank you. We're going to go to House Bill 1320. The last bill. Delegate Erican for 3 minutes, then Lisa Jordan and Vanita Taylor for 2. They are both in opposition. We'll hear from Delegate Erican to begin, though. Delegate Erican, please, for 3 minutes.
Thank you, Mr. Chair. So HB 1320 is a bill. Oh, by the way, my name is Delegate Lauren Arkin, for the record, District 7, Hartford and Baltimore counties. This bill is seeking to address a problem that happened in my community over the last, I want to say 15 years or so, maybe a little bit less. One family in particular, who I'm intimately knowledgeable of, had an issue with one of their minor children. The child was found to be molesting not only his own siblings, but also multiple children in a larger community. And when the information came to light, there was a great deal of effort on the part of our community to help the family and get the child the services that he needed to mitigate the behaviors that he was struggling with, while trying to maintain protections for the young little girls who were being impacted, who were ages, I believe, 5 and 2 at the time that all of the information came out publicly. Over the course of several months, the child did seek therapy, and there was no reports to the state. Eventually, however, what came to light was very disturbing. The parents were actively allowing the child unrestricted access to not only the siblings that he had been molesting, but to other people's siblings and children who were not aware that the child had sexual behaviors that he was exhibiting and that were sometimes violent in nature with other children. The parents knew what he was capable of, knew what he was doing, and essentially were procuring victims for him from the community. This bill directly seeks to penalize parents who know what their children are doing to other people, but purposefully and willfully hide that. I have had another victim come forward to me this year, and she would have loved to have been here to testify. The case with her child is currently under criminal investigation, but needless to say, this mainly occurred about when all the information came out was about 7 or 8 years ago, and it is still occurring today by this child. who at this point has been through the DJS system, and the parents are still not restricting his access to minor children. So this is exactly what this bill is trying to address. If you know or should have known that your child is hurting other people's children in a sexual way, you are going to be on the hook for it. Thank you.
Are there questions for Delegate Erican? Okay. All right, seeing none, thank you for that. And we'll now go to those in opposition for 2 minutes, Lisa Jordan and Vanita Taylor. Lisa Jordan. Lisa Jordan. All right, Lisa Jordan now for 2 minutes, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. And we are, I am sorry to say here, in opposition of this bill. I am heartbroken to hear this story, but we must ask for an unfavorable report on House Bill 1320. Primarily, we really don't feel that the criminal justice system is the appropriate place to say that parents who are perhaps helping a child who has been sexually abused themselves and then acted out sexually, having these parents, face criminal penalties for allowing the child to continue on after treatment is not appropriate. Hearing the facts from Delegate Erican, which I had not heard before, I have to say, I just got out the law book myself, and I do wonder if the parents were actively procuring victims for their child. I think that's already covered under our criminal law. So I don't think that it's necessary if we have someone who is procuring other children for a sex offending child. I don't know that we need additional statutes, but I did provide the committee with some written testimony about kind of the way children come to commit sexual behavior problems, 48% of them being sexually abused themselves, 32% being physically abused, 35% emotionally abused, 16% neglected. A lot of times these kids really have their own difficulties, and I absolutely am not saying that we shouldn't respond to them. I would, however, suggest that the criminal justice system is not the appropriate tool to use against their parents in these very difficult situations. So with those comments, we do respectfully request an unfavorable report. I'll also say that the Committee to Protect Maryland's Children, which is a larger group of organizations committed to protection of children, also had that same feeling that it's just not the right tool to respond in these difficult cases. Thank you, Mr. Chair.
Vanita Taylor, please, for 2 minutes. Ms. Taylor, go ahead.
I'm here, Chairman Clippinger, but I'm still hearing the end of the testimony of Ms. Jordan.
To close
Hello?
the, yes.
I'm here.
You need to close the YouTube link.
No, okay.
Close the YouTube link. Keep the Zoom link open.
Okay. Hello. Good afternoon, Chairman Clippinger and Co-Chairman Moon and other delegates. I'm Vanita Taylor from the Office of the Public Defender. I'm here to close it. All right, are we good?
Should be good. As long as you're not getting feedback, you should.
I'm not getting feedback.
All right, go ahead.
Well, good afternoon. I'm Vanita Taylor from the Public Defender's Office. I have been involved in child welfare for almost 30 years. The Public Defender's Office, in opposition to House Bill 1320, this bill is overly broad, it's vague, and it has no intent. I understand that the testimony given by the delegate and the system failed that family and failed that community. But this bill is not a corrective matter for that issue. This bill further penalizes parents, regardless of whether they knew that a child had committed some kind of offense, a sexual offense or misconduct. It's not an intent bill. It doesn't say anything about intent. It talks about parental mistakes or poor parenting. How would a parent know or should know unless the child was committed to the Department of Social Services, charges pending, a report filed with law enforcement? Other than that, a parent may not know. And what you would have is expecting parents to have a crystal ball. You should or would have known this. But how would you should or would have known this, that this offense was committed? Because commitment is actually a term of art in juvenile court. Commitment means that there has been a finding that the offense did occur. In this bill, committed is just committed a crime or crime prohibited under this section against another minor child, whether or not the crimes were reported to law enforcement, the previous offender was charged with convicted or found responsible for the crime or crime. So you really, in juvenile court, you can't be a previous offender unless you have been committed and found involved, or as a young person, or convicted if it was charged in criminal court. Without that, it is just speculation and gossip. In fact, you are asking parents to do something that they may not have any real knowledge that it actually occurred. This bill is not in the best interest of children. It further criminalizes their parents' behavior for making a mistake. It also raises the bar for parenting. It creates a high standard of care without sufficient knowledge, without any intent. A parent could go to jail for up to 2 years.
Ms. Taylor.
For an inadvertent act. The public defender's written testimony does talk about the fact that children who have been found to be involved in sexual misconduct are the group who are the least likely to reoffend. That is all in the written testimony. I will not repeat it, but I will say that this is not in the best interest of Maryland's family or children. It is too vague, overly broad, and creates a speculation. It relies upon gossip and innuendo as opposed to proven facts.
Thank you, Ms. Taylor. All right, we have questions. Delegate McComas to begin, then Delegates Cox and Munoz.
Thank you, Mr. Chair. I have some questions, and I think the issue is, you know, parents kind of would, if a kid was abusing other children, they would likely hear it from someone. There would be some suspicion, and that they would try to, hopefully they would investigate. That's my thought. So with that said, a lot of times if kids are bullies, or kids are this or that, or they happen to be kleptomaniacs or things like, you know, like to steal stuff, the parent will eventually find out. You know, parents usually a good parent usually keeps a good eye on what's going on with their kids. Wouldn't you say?
I would say that the definition of a quote unquote good parent varies and is broad. The fact that a parent may not know does not make them necessarily a bad parent. And why would Maryland want to criminalize someone for being a bad parent? Or being a poor parent when they themselves did not commit any act and were no way involved, because it's not an intent crime.
Okay, Ms. Taylor, what if the parent knew and didn't do anything about it, and knew that their child was violating other children or younger children?
Under Maryland laws, if a parent knows that their child is committing a criminal act, they can be criminally charged as a co-conspirator. We have laws that already handle that situation.
Okay, so basically, can this bill be fixed, or you say we don't need it?
I don't believe we need this bill. I don't believe this bill provides a protection that the authors think that it does. Parents can already be charged under criminal neglect. There's a criminal neglect statute in the state of Maryland they could be charged under. The parents, for the failure to protect other children in the home, could have a charge of a child welfare charge brought against them, and their other children removed from their care. There are already enough protections in current Maryland law.
I'm going to give you a little hypothetical and see. Okay, now we say that a lot of times sexual child abuse can be if you were sexually child abused, it's possible that it can be that it could be generational. Okay, that basically it passes through unless there's a major intervention somewhere along the familial lines. Would you agree with that?
There are some cases like that. In fact, many years ago, I represented a mother in a case where her father, who was developmentally disabled, had fondled her children. And her children then had activities in the home when the parents were at work with other children in the community. What the response to that was that a child welfare case was filed. The mother's children were removed from her until protective factors could be put in place. She was not criminally charged because of what had happened to her as a child, and that she should have known that this would happen to other children in the family. It could be passed down. She was not aware of that, but the right remedy was child welfare stepped in and created a protective plan for those other children.
Right, but perhaps would it be better if I'm just playing hypothetical. If this bill were passed, hypothetically, it would kind of put parents on notice that to maybe kind of keep an eye on what's going on with the kids, and that they're not abusing children, that then it just kind of carries on child after child. So that in other words, it stopped, because it sounds like a lot of people don't necessarily want to involve the quote system, child welfare, because they're afraid their kids might get taken or whatever. But if the bill were passed, it's kind of like a public statement. Hey, you need to kind of keep an eye on what's going on. Just because it's on the books doesn't mean that it has to be prosecuted to make an impression, is what I'm saying. So maybe if it's on the books, could it help prevent this?
I don't believe that this being on the book would help prevent it at all. There are many laws on the books that people are unaware of. This is not a protective bill. This is a prosecutorial bill where you are prosecuting parents for their lack of parenting skills or their lack of knowledge.
Well, you're assuming they have a lack of knowledge. I got the impression from the sponsor's testimony that they knew.
Yes, in that particular case that she illustrated, she said that they knew. However, the bill doesn't say that they knew. The bill does not have any intent in it. The bill says basically that they don't have to be. It doesn't have to be reported to law enforcement, and they don't have to be charged, no conviction, or found responsible for the crime or crimes. We're talking about children. We're not talking about adults.
Well, so you don't feel that it could be amended?
No, I don't think that this particular bill could be amended.
Okay. Thank you very much, Ms. Taylor.
Delegate Cox.
Thank you, Mr. Chair. May I ask a question of the sponsor?
I just said to Delegate Long, I'm sorry, no.
Okay, that's
We're
fine.
on the opponents, so no.
I'll go right into Ms. Taylor then with this question. I'm frankly a little bit surprised at the esteemed members of the panel that defend women and children from violence, that would be opposed to something so basic and straightforward. And so I have a couple quick questions to clarify what I believe are misleading or misunderstood at a minimum nature points of the bill. I heard, first of all, Ms. Taylor, that you said that this bill can affect someone who didn't even know, parent who didn't even know it was going on. But the bill on page 1, line 18 says that this is for a knowing parent or legal guardian. Isn't that true?
It says on line 18, knowing parent or legal guardian means a parent or legal guardian of a minor who the parent or legal guardian knows or should know is a previous offender. And you can't be a previous offender under Maryland law unless you have been adjudicated to be an offender, that you committed an act.
Right.
And the bill goes further to say, however, you can be labeled a previous offender whether or not you were charged, whether or not you were committed, whether or not you were convicted.
It doesn't say that though. It doesn't. In fact, it says on page 2, unless, I mean, correct me if you have a line where I'm not reading it, but on page 2, it's very clear. It says that a previous offender is charged with, convicted of, or found responsible for crimes. And a knowing parent is one who may not, who has knowledge of that information, may not allow the person, the minor, to be around other kids without adequate supervision. I mean, it's a pretty common, straightforward approach. Wouldn't you say?
No, it actually doesn't. You got to go back to page 1, line 23, where it says whether or not. That's an important distinction. Whether or not the child was charged or convicted or found responsible.
The previous offender, okay, let's read it. Previous offender means a minor who has committed a crime or crimes prohibited under this subtitle against another minor or minors, whether or not the crime or crimes were reported, or the previous offender was charged with, convicted of, or found responsible. So all that's saying is that if the parent has knowledge that the child was committing these crimes and refused to report it or did not report it, they're still, as long as that fact can be established that they were in fact doing that still makes them liable. And it doesn't necessarily make them I think you mentioned a co-conspirator, that the law covers that, but that's not what this law deals with, because co-conspirator would be somebody who would be actively engaged in the crime itself, rather than turning a blind eye or pretending to not know what's going on. I think that's the focus of the bill, and it's pretty clear, and I don't think it's subject to confusion.
Well, Delegate, I believe we can agree to disagree. I believe that this bill, and that's the problem, this bill is vague and overly broad.
Well, I submit that, you know, if the biggest concern you have is the whether or not, I certainly would love to hear the sponsors' thought about that, because the bill as a whole, I mean, let me just ask you this, Ms. Taylor, if you were to strike that one line which you point out that you have a concern with, the whether or not, would you accept this, that if a parent knows that their child was charged, convicted, or found responsible for one of these crimes and actively refused to supervise that child, wouldn't you agree that that would be an appropriate bill then at that point? Would you support it?
That would be it. That's a different bill. In fact, under child welfare laws, a failure to protect is already under criminal neglect. That is already a crime, a failure to protect, because that's what it would be.
Well, but isn't that a failure to protect the child that you're in the guardianship with? It doesn't, you can't be, you have to be under the neglect law. You have to be the person in interest. You have to be the parent or the guardian. And that's prong 3 of the test. You can't be charged for neglect of somebody else's kid. And if they try to charge you for neglect for not adequately supervising your own child in a play situation, that neglect has never been defined, to my knowledge, to have knowledge of that child's prior criminal activity. So in other words, it would not apply. Neglect would have to be defined under the statute, which says a child has been willfully not provided for in the context of physical health, physical, food, clothing, education, those kinds of situations, not letting them play with other kids, knowing, or hang out with kids, knowing exactly what they've done in the past. So that would be my concern, but it sounds good. It sounds like you're almost there. It sounds like if we struck whether or not, then it might be broadly acceptable. I think it's a great bill. I think it's important because I have done some practice in this area, and I hear the concerns. It is a need for parents to step up to the plate and protect other kids. And as we know, nobody else would have that information. Only the parent would know. So it's important, I think, to help them to be encouraged to do what is right for all of us. But thanks for your time.
Delegate Erica had lowered her hand. Seeing no further questions, thank you all very much. That concludes the testimony on House Bill 1320, and that concludes the testimony for bills today in the Judiciary Committee. We're going to have a voting session at 4:15. I've been told that I am doing my very best Joe Valerio impression. It's not willful. It just is what it is. I'm going to give me 45 minutes, see if I can drink a little more water, and we'll be back with a voting session then. So